Welcome everybody to the MAREI PartnerCast. Today on the call, we are talking with attorney Rick Davis, and we're going to ask him a few questions that we've been seeing happening out there on the Facebook groups, and a new question that I didn't even tell him I was going to ask him, so I'm going to put him on the spot with a question here in a second. But first, Rick, tell us a little bit about you, about your firm, and how it's a little bit different than the average firm.
Sure. So as you said, I'm an attorney. I'm licensed in Kansas and Missouri. One of the things just about me individually that makes me a little different, I'm also a licensed real estate broker and title agent in both states too. So I have kind of a full-rounded knowledge of different things dealing with real estate. Everything that I do is real estate related. I always say the best way is if it involves property, I probably do it. If it doesn't, I probably don't. And, you know, again, my focus is really real estate investors. So I would say 99 out of 100 of my clients are someone who might be listening to this video, whether they do fix and flips, wholesale, whatever it might be, all different spectrum levels within the spectrum, but that's kind of my ideal client and the people I like to work with. You know, I think one of the biggest things that makes my company different than other law firms in particular that you go to is that we don't believe in the billable hour. I don't believe in the billable hour. You know, with years of working with real estate investors, I've seen a couple things. Number one is I think it just creates kind of an almost adversarial relationship between the client and attorney, because you don't want to call and ask that simple question because you know you're going to get billed in 6-minute increments. And there's always that question of, well, we spent the first 2 minutes talking about the weather. Did I just pay $250 an hour for that? And so I've tried to build a structure with my firm that encourages my clients to call out. I want them to call because many times if you call with that quick question that takes 5 minutes on the phone, it avoids the $10,000, $20,000 litigation down the road or the problems. And so that's why I really tried to build this company to be different, to where we're proactive with my clients and that they're encouraged to call instead of worried about that bill every month.
Cool. Well, that's one of the questions I really wanted to know is what makes you different, because I know so many times, like you said, the real estate investor's afraid to call, and my son actually kept asking us questions and we're like, no, we can't answer that question. You really need to talk to an attorney. And he called and talked to an attorney, and of course they spent 15 minutes on the weather, and he got billed for that 15 minutes on the weather, and he was just none too happy. So that helps quite a bit there, so we're not afraid to call and ask a question. So here's the big question. You didn't join us. We just had a meeting on our MAREI roundtable, and the big question everybody had was, as you know, the CDC eviction moratorium was found unconstitutional in Texas. Does that mean anything for investors in Kansas and Missouri?
So, lawyer answer, yes and no. Not what people hope it does. And I actually saw some social media discussions on this morning too. And, you know, I put together actually a short video on my site talking about how the federal courts work, but the basic gist for everyone to know is that court decisions are only binding downward. And so there's trial courts or district courts throughout the nation. They can actually reach inconsistent decisions. And so what a judge in Wichita, Kansas says might be different than what a judge in Kansas City says looking at the same laws. So this case came through Texas, and so it's not binding on any of our courts here. So in Kansas and Missouri, it doesn't mean that any of those judges have to follow that or that they're going to be bound to do what this judge in Texas did. But it is persuasive. So there is some positive effect to it in that, you know, judges will often say, okay, I read this decision in Texas, I agree with this logic, so I'm going to make an independent decision based on what that judge said. But it's not binding and they're not required to. And so it's not what I know I think some people hoped when they saw that this morning, the ban is lifted. That's not true, but it's one step in the right direction. It's a positive decision. You know, and hopefully, and kind of this is one thing I said this morning too, the current ban right now expires the end of March. Now, I know that Biden said he was going to extend it through, I believe, October in some of his campaign materials when he first came into office, but it hasn't been yet. So maybe this decision helps weigh on them to just let it expire at the end of March because they don't want to deal with legal challenges and things like that and not extend it further, because we've also seen a big drop in COVID numbers and everything else. So I think it's positive. It's definitely not just a blanket win, unfortunately.
Okay.
So,
and you said you put a video up on your website about this?
It's not about the CDC issue specifically, but just how the federal courts work.
Okay.
So if anyone has any kind of questions about how, because I get that quite a bit too, you know, a lot of times it's a California decision because California and the Ninth Circuit does things very different than a lot of other districts and, you know, very liberal state. I'll have clients call me up and go, well, I found this decision on Google. Does this mean I can't do X? And well, not necessarily. And so that's kind of what I talked about in that video, is the difference between the different districts within our country.
So the only way it was going to affect everybody was if it was at the Supreme Court and passed the appeals process.
Correct. Yeah. So that's the only way it'd be binding on the whole country, is if the Supreme Court.
Okay. All right. Well, that was the extra question that happened this morning. So we added that in there. But one of the things that I've been seeing a lot on Facebook is, okay, I need to get an LLC. Well, one is, and I know you can't dig in deep, or your answer is going to be, it depends. Is an LLC right for me? So we're going to get past that. You should talk to an attorney. We're not telling you go form an LLC to hold your real estate in. Go talk to an attorney on your situation to make sure LLC is what you want. But when you do decide you want an LLC, should you just go file with the state and magically you've got an LLC, or should we hire an attorney to build that LLC?
Yeah, and I think that's kind of great how you framed the question. The actual formation of the LLC, so the paperwork with the state, is simple. And you've known me for a while now, Kim, I don't oversell. And so, when it comes to actually forming the entity, it's pretty straightforward. But there's really the kind of two bookends to that question that I think you addressed in the way you ask it. One is the front end, which is making sure that an LLC is right for you. Maybe it's multiple LLCs, maybe it's rarely a corporation we're dealing with real estate investment, but it might be, or it's a series LLC. So that's the front end. And then the back side is making sure that you know what you need to do to keep the LLC protection. And so, anyone can go on the Secretary of State's website, take about 10 minutes, form an LLC. It's now formed. But we don't do it just to have a business name. We do it so that we have the legal protections in place if something was to happen, if someone sued you, someone slipped and fell on your property, died, something like that. And so there's that backside too, which is making sure that you keep separate bank accounts, making sure that you sign all of your contracts in the name of the LLC, that you act as if the LLC is a separate entity from yourself personally. And so, I think my answer would be is that I would recommend that anyone kind of new to this business or industry or having entities should talk to an attorney, go over in more depth than I can in a couple minutes here, on this conference, about what they need to do to make sure that they're in compliance and to make sure that it's the right structure. Then if you want to form your own, maybe save a few dollars there. I don't, see big problems with that. Again, just making sure you understand those kind of bookend sides that isn't the form on the website. Because, I don't provide a lot of value filling out a form. I provide value in telling you which form to fill out and what you do after you filled it out. And then the other kind of caveat, too, I'm kind of answering this question a little bit in the context of a single owner, because that's where you're just filling out a quick form. You have an LLC. If you're going to have multiple owners, especially if they're not spouses, but even spouses, because divorces happen, I don't care how happy your marriage is today, you don't know where it's going to be a year or 2 or 3, 5 from now. That's where an attorney is important as well, because getting that operating agreement in place that you understand what happens, especially if these spousal situations, you love each other right now, you're making all decisions in tandem, you get a divorce, and all of a sudden one wants to do one thing, the other wants to do another. How are those things going to be settled? Who gets the money? And so, that's the other side where an attorney comes into good value is if you're going to have any kind of partner, even if it's a spouse, making sure that you have kind of those operating agreements drafted.
Okay, well, that's good to know. I see so many people, they're just like, just go form it. And I'm like, well, no, that's not it. There's more to it than that. But the other thing, I'm a realtor, and I haven't represented other buyers a lot lately, but I know when I was representing investor buyers buying in their LLC, they all just signed with their own name at the bottom. And I was like, I just cringed because I thought that pretty much invalidated the whole LLC purpose if they were just signing by their own name. Do they need to put words after their own name if they're buying in their company name?
If the company name itself is on the contract, and then, because obviously when you're dealing with a real estate agent, we're dealing with board forms and specific forms that you can't really change. If the company name is what's written as the buyer and then they're signing as a member, ideally they should sign, Kim Tucker, member or managing member or manager, whatever the title might be. That would definitely be better. I don't think it's a huge risk as long as the company name. The bigger issue is when they do the contract in their individual name and then want to put it into the business. But now this contract is, clearly individual. So. Okay.
All right. Although I do know we a lot of people will buy in their own individual name personally, and immediately after they purchase it, they're buying it in their own name for financing purposes, and then immediately deeding it to their LLC. Now, whether that invalidates the due on sale clause, everybody says it does invalidate it, but the bank doesn't care usually. But I have heard instances where the bank has cared and you've had to reverse it the other way. So that was one question that I had there. The other thing I see a lot on Facebook is I need a real estate contract, or I need an assignment form. And I know a lot of people just go to Google. Can they do that? Or should they have an attorney draw up the contract? Or should they borrow a contract from a friend? What should they be doing on contracts and documents?
Yeah, so there's probably a lot of little nuances to that. I'm going to start with a basic premise that I always say, which is if you're using a standard or form contract, it's just that, it's standard. And so, for example, we mentioned board contracts just a moment ago with residential real estate transactions. 99% of those transactions fit within a box. They're individual buyer selling to retail seller. There's agents involved on both sides. It's kind of a standard transaction. They're going to get a loan or they're going to pay cash. In those kind of instances, form contracts work because you fit within the box of what that contract was made for. Where the form contracts start to become less effective is when you get outside that box. And this is where, and even specifically talking with real estate agents, specifically involved transactions too, where I do see issues down the road, is because we've tried to use a board form for something that really didn't fit that box. And so maybe it's some kind of creative wraparound seller finance, or they're a subject to purchase, for example, where maybe it doesn't fit quite right on the forms. So I think that's kind of the default answer that I'm going to start with, which is a form contract, again, works for the stuff that fits within that box, the standard transaction. The further you get away, the less you should be using that standard form. The other half to that, and this is, I think, because you mentioned, should we just Google? And so that I'm talking about is a prepared form made for real estate agents with Kansas and Missouri attorneys who've looked it over on a yearly basis and make changes. I would caution very much for the just Google and find something for a couple of reasons. Number one is, and I see this a lot as an attorney, is people find something that's in the back of one of the books they bought from a guru that maybe is based out in New Jersey or Texas. Texas is a big state, right, for these kind of gurus. And the problem is that those aren't catered to local law. Now, many times it may not matter. There are times it does. There are times it doesn't, depending on whatever variance is. But as we talked about earlier, the federal courts can make different decisions. States have different laws. And I think most people on this who are listening to this probably know that, since we're on a state line. In Kansas, you do a judicial foreclosure. In Missouri, you don't. I mean, obviously, there's vast differences in some of those things. And so, when you're taking that New Jersey form contract that you just got off the internet, and it maybe deals, it's a seller finance, for example, and it deals with a judicial foreclosure, but you're in Missouri, you might have some problems. And so you might be forced to go through a process that you didn't plan on and spend more money on a lawyer. So I'd be very cautious. Now, that doesn't mean, though, that form contracts, again, can't work. And so, like, for example, you talked about some of the different things with my firm. One thing that I am working on, which will hopefully roll out next week, is a document store through my website, which would be local forms built for local transactions. And I think we're going to have somewhere close to 200 different forms that will be available when that launches out. And so, if you're buying a form that's local, and again, that's been vetted by a local attorney and that deals with, that specific transaction fits within the box, there isn't necessarily something wrong with the form. But again, even with my forms, if you start to get away from that box of what that transaction is, that's when you might want to bring in an attorney. And then and I'm probably long-winded, I'm a lawyer, sorry, but, the last point I'll make is if you're anyone who's doing any kind of volume, so, obviously there's the different side, there's someone just getting started, they've got one flip going on, or someone that has 200 per year. If you're anywhere kind of closer to that bigger side, what I would recommend is just to get your own form contracts. Pay an attorney once to put together that contract for you that's going to fit your specific situation. If you look at like commercial landlords, for example, that's how almost all of them do it. If you're renting space down from Corporate Woods, they have their form contract. So it isn't something they just found off the internet, but they aren't paying me, or wouldn't be me with Corporate Woods, but their attorney every single time to draft a new contract either. They just fill in the blanks. And so, I think as you start to scale your business up, that's where you should head. Is, hey, let's start with this form contract. Let's make it fit the specifics of my business model. And then you use that every time. And then, maybe you only have to come if you're doing something that's kind of outside the norm.
The other thing I've noticed, I'm a realtor, I have access to the board forms and I use them when I'm selling houses on the MLS. But I've also noticed that I don't even know how many pages it has anymore, because last time I looked at it, they've changed it again. We had 4 pages in a real estate contract when I became a realtor. And I think that standard 4-page contract is now 12 pages, maybe something like that. But the one thing I've noted about the board contract, it's not written to protect me as a buyer, and it's not written to protect me as a seller. It's written to protect the transaction, the realtor, and the title company from getting sued. And while it does, it's neutral to the buyer or seller. It's not a pro seller or a pro buyer. And when I'm selling as an investor, I want more clauses protecting me as a seller. And when I'm buying as an investor, I want more clauses protecting me as a buyer. So I have clauses that we've worked on for years that we insert into the board contract that are standard on our regular contract that we've worked with investors, so that we are protected. The one clause I'm still working on is non-refundable earnest money, because it seems that the title companies will not honor any clause we put in anymore. So I used to be able to have a non-refundable earnest money on my contract that the buyer agrees to, that, you know, if they don't close like they said, I get the earnest money, and I can't get a title company to honor that anymore. So maybe you have a secret to that, but that's a question for another day.
I'll tell you one thing that you could consider, which I know another one of my clients is doing, is just have the deposit paid to you instead of the title company. I mean, that's how builders have done it for years now. Almost any new construction contract, you pay the deposit to the builder. That's really the only good answer, because title companies don't want to pay 10 grand in legal fees on a dispute over who gets the $1,000.
Right. So that's one of the things that we've done, is we used to have the clause, but when you're closing with the title company, if I know most buyers do not want me getting the earnest money. Of course, I mean, it would be different from different negotiations, but I've found that when I list it on MLS and they're represented by a buyer, no way is that buyer's agent, if they're doing their job right, going to let them pay the earnest money to me. So, well, that was my big questions that I had for you, but I'm sure you've been getting a few other questions that you might have had in the past couple months that you wanted to touch on. So I was going to see if there's anything else I should have asked you that I haven't.
Yeah, we did kind of hit all that pretty quick. So.
Yeah.
Which is good. And so, definitely I'm trying to think of some good reoccurring. Obviously, the eviction moratorium is big right now. I know you've done quite a bit on it, Kim, so I'd imagine most people that are watching this probably know, but, it applies to income-based issues. It's not everything. Talk to an attorney. Julie, I know, does a great job and can talk about that. So that's definitely, I know, an issue that's come up probably more than anything right now. The other one that I just see every other day, it seems like, is emotional support animals. And that's almost a whole other conversation on itself. The bottom line being that you have to accept them and you can't charge pet rent. I'm trying to think what else is kind of reoccurring.
Do you think that will change now that the airplanes don't make, I guess airlines are not letting emotional support animals on the plane any longer, although that was a just before COVID thing. Do you think that would affect emotional support animals in houses on down the road?
Well, I hope so. I mean, there's definitely a counter movement, if you want to say that, a landlord side movement, because I think anyone who's intellectually honest will admit it's being abused at this point. I mean, I'm not going to say there are plenty of people, I'm sure, that legitimately do need an emotional support animal that provides value. There's also plenty of people that go on the internet, get a letter, and it gives them an excuse to have a dog in your apartment. And so I do think it's headed towards some changes because there's quite a bit of push to do that. And I know a few states have actually passed laws to try to crack down on just, making it criminal, for example, to fraudulently say you need an emotional support animal. So I think it's headed that direction. And, like everything, though, COVID has slowed down everything. So we'll see when stuff like that gets back on the front burner.
Yeah, it'll be a whole different world when we all go back to the new normal, whatever that's going to be. I think it's going to be different. The other thing you've touched on, I think, and I think last time you spoke at MAREI, you touched on it, and we were talking about the guru attorney firms that you find on the internet that want to sell you the Cadillac of Cadillacs for asset protection and have you form your LLC in some other state. Is that overkill? And what's the point of forming an LLC in some other state other than the fact it only costs $5 in that state to form the LLC or something? I don't know I've never understood why we should want to form an LLC in another state if we're doing business in the state we're in.
I think it's a great point, and you mentioned it a little bit ago with the realtor forms, and it seems like I'm going on a tangent. I'm not, I promise. But one of my big beliefs in life, kind of as a professional, is always kind of look at the angle of what someone's coming from. So you look at those board forms, that's a realtor association. So obviously, the interest they're looking out for the most is going to be the realtor association, the realtors or the brokers. And so kind of the same thing here. When you look at a company, and most of them are based out of whatever state they're selling, so let's say it's a Nevada company, for example, or I know some big ones in Texas or things like that, obviously they're selling you on forming it in their state and then often paying them for some kind of additional service, which I'll talk about more in a second. And so kind of, A, look at their motivation. B, a lot of times the protections that they're selling either are a little overstated or they're stuff that you can get here anyway. So take a Wyoming LLC. One of the big sells that they talk about is the fact that it's harder to get a charging lien, or it's just a charging lien that can't be enforced. And so basically, kind of not to get too far down into the minutia here, but the purpose of forming an LLC or any kind of entity is to try to isolate your personal assets or maybe segregate business assets as well, but to keep it to where you only lose what's in that LLC. So, if you have $1 million in retirement sitting in the bank, and you're investing in real estate and something happens, in one of your properties, well, they can get that property, but maybe they can't get to your retirement funds. And so, one of the things that's sold by these Wyoming companies, for example, is this idea that you need to keep your LLC certificates in the state of Wyoming, so that way you can apply Wyoming law to charging liens, which basically means that the court can't force you to distribute assets from your LLC. And so, they can only garnish, and I know I'm getting a little minutia here, but if a judgment's entered against your business, and so someone sues you, they get a large judgment, one of the ways to collect that judgment is through garnishment, most commonly thought of as an employer. So if you work for someone, they can garnish your wages and take a portion of it, usually 25%. You can also garnish, for example, if you received a distribution from your LLC. So if your LLC pays you, they can take a portion of it. Well, in an LLC, you can choose not to distribute those funds and leave it in the LLC. And so that's where you get into this charging lien concept. They've got a lien against anything that does get paid to you, but if you choose to just keep cycling your money, so you take it from one project to another, and don't disperse it, they can't force you to push that money out. Some states let you force that out. Wyoming is one that doesn't. Kansas also doesn't. And so if that's the big sell that they're trying to sell you on this Wyoming LLC, which is 99% of the time what I see, you can get the same protection in the state of Kansas without having the added complication. Number two, I'm going a little bit, I've got 3 points here. Number two, even if it's cheaper in that state, your cost savings are usually negligible or non-existent because you still have to register it if you're going to be legal. A lot of investors don't, but if you're going to follow the laws, if you have a Wyoming LLC, a Texas LLC, Nevada, whatever it is, and you own property in Missouri, you need to register it in the state of Missouri. The fees for registering a foreign entity are about the same as registering it in Missouri in the first place. So now you've just paid, essentially double money to have it in the other state. And kind of the third point, and I just had this conversation with someone yesterday, I think it was, that you get sold on a lot is this concept of anonymity. And I think that anonymity is extremely oversold when it comes to real estate, whether it be entity structures. It's not always LLCs. Sometimes it's talked about in land trust concepts. And this is what I always say to people. Can you make it harder for John Smith to get on the internet and find you on the Secretary of State's website? Absolutely. You put 3 layers deep, you don't use your name in the entity, John's not going to be able to just go to the Missouri Secretary of State and find you very quickly. But if John is just looking for his small claims case and can't find you, that's really not what your entity protection is about. Your entity protection is about that big lawsuit where someone's going to come after you for $100,000 or $1 million or whatever it might be. In that instance, John is going to come hire me, and I'm going to figure out who owns your entity every single time. And so it might take me a few more hoops to jump through. It might take a little more research of work, but we've got access to database and things, and attorneys being the we that I'm referring to, that we can usually figure out who owns something. So I would say that unless maybe you're a celebrity, so you don't want your name on the property because you're Patrick Mahomes, for example. So you maybe want to hide it a little bit so they don't just find you on the internet. Or Kim Tucker, celebrity in the real estate investment world. You may not want your name out there for that reason. But, unless it's for that purpose, if it's for this idea of thinking you're going to avoid lawsuits, I caution people, it's just not going to happen. If someone has a good suit, they're going to find you, even if you put 12 layers of anonymity between you and that underlying asset.
So have insurance, have your
Yes.
corporate layer, and then have checks and balances so that you can prove you're doing things right. And then you can't come sue me anyway. I mean, you could try, but you'd lose as long as I'm doing everything right.
Exactly. And that's a good point, too, just as you talk about common things that you talked about. I get the question, one of my favorite questions I get all the time is, can a tenant, can a buyer, can a whatever, fill in the blank, sue me over this? They can always sue you. So there is no safeguard. I can go down to the courthouse right now and file a suit against Patrick Mahomes because I don't like him. I do like him, but I'm just saying, as an example or whatever it might be, no one can stop you. It's just you're going to win at the end of the day at the lawsuit. And so, yeah, and you kind of made that point. I always like to make it, too, because I get that question a lot, and as a lawyer, I can't just say, well, no, they can't sue you, because they can't. Just like people put, and I'm sure many people who listen to this have dealt with it, fraudulent mechanics liens. It's kind of the same thing. I mean, there's no one at the courthouse verifying whether that person actually did work for you. They accept it, and then you've got to deal with, getting rid of it when that happens.
You mentioned that if we formed an LLC in Nevada, but we're owning property in Missouri, that we need to register as a foreign LLC in Missouri. But a lot of us, since we're here on the state line, do business on both sides. So if we have an LLC in one state, should we be registered in the other state?
Yes, and I'm a practical attorney, so I'm going to kind of give you the full answer here. The legal answer is just yes. There's no gray to it. If you do business in a state, you need to be registered as a foreign entity. And so, where you get into where there is a little gray is what's doing business. I mean, if you own properties in Kansas and Missouri, you're doing business in both states. You need to register. If your house is in Kansas, but all your properties are in Missouri, maybe it's a little grayer. Are you doing stuff from your house? Do you have a separate office? That kind of thing. But the bottom line, though, is pretty much just yes. If you're doing things on both sides of state lines, you should register as a foreign entity in either both states if you have that out-of-state LLC or the one you're not registered in. Now, the other half to that, though, which is why you see many investors that don't, is what's the practical effect of if I don't follow the law? Well, the truth be told, there's no one out there regulating and looking for, is this entity registered in this state like it should be? The place where it usually comes up 9 out of 10 times is in a court proceedings. And so if you wanted to sue someone, let's say you're a Missouri entity, but you're not registered in the state of Kansas, but someone does you wrong in Kansas for whatever reason, they crash into your car or business car, so business is suing, or something like that, you can't avail yourselves of the Kansas court. You can't sue in Kansas when your entity is not registered in Kansas. And so now, for the most part, courts let you just go register and then file your suit so you can correct it. So practically, there isn't a whole lot of penalty if I'm just giving an honest answer for someone not doing it. I'm personally just a believer, it's $100 and some to register your foreign entity and $50 a year for an annual report. Do it the right way. Follow the law. It is the law. But practically speaking, there's not a whole lot of, penalty or effect if you don't.
Well, I'd never had it come up, and then we bought a note in Utah. And while I was able to foreclose the note not being registered in Utah, when I went to sell the house, the title company wouldn't sell the house unless I registered in Utah. And we've done this in several states, and that was the first time it ever came up was Utah. Even because we're a Missouri corporation or a Missouri LLC doing business in Kansas and buying and selling in Kansas, and we've never registered in Kansas, and nobody's ever asked us about it. So I didn't even know that. I'd never heard that until you mentioned it at a meeting at some point. So that's something new.
Yep. Well, and that's I'll kind of last point too on that topic is too, when you're using the form contracts, whether it be one you got from an attorney or probably with the notes you're probably using the Fannie standard instruments and those kind of things, usually that review is pretty inexpensive too. I know, like when someone gives me a realtor board contract and says, re-review this, I'm not going to charge them like I would to review a 20-page contract because I know what 90% of that document is. I'm looking for things crossed out and changes, and that's all I actually have to review. Same with the standard notes and mortgages. And so that's the other thing I'd say probably too to newer investors. A lot of times an attorney is not as expensive as you think. Litigation is very expensive. I'm not going to lie. You end up in court, you're going to spend a lot of money. Having an attorney just check over your closing paperwork is probably far less expensive than most people realize.
And so if it's something you're doing over and over and the standard, that's one thing. But if you're doing something weird or different, we should probably at least make a phone call and see how important that is. And even with other attorneys, I know a lot of investors are afraid of paying for that 10 minutes about talking to the weather, talking about the weather. But I know most attorneys will, if you have some issue that you're not really sure about, they would do a first initial consultation on that issue to say, yes, you have an issue, or no, you don't, and wouldn't overly charge you for that. Is that kind of, that's the feeling. I know people are afraid to call an attorney, and it's not really $500 every time you make a phone call, is it?
It's not with me. I can't speak for every, we all bill different. But yeah, I mean, on that, it depends a little bit the type of thing that you're calling about. If it's a litigation case, you might be more likely to get just a free kind of general answer. If you're getting into specific advice, you might pay something for it, but it's definitely not 500. And if you spend $50, $100 to get a quick answer to something, again, that might save you a lot of money down the road.
Well, I know.
It is a little, so.
I was there when I was first. I'm like, I don't want to pay an attorney, and like that. So, but now I'm just like, here's the issue: is this worth my time to pay you, or am I wasting my time? And at least the attorneys that are around MAREI, whenever you or any of the other attorneys at MAREI, when I reach out to them, pretty much they're all like, yeah, that's an issue, or no, it's not. And if it's an issue, then I'm going to pay them. And if it's not really an issue, then we just go on down the road and don't worry about it. So.
Yep, and I promised I'll stop going on a tangent, but the last point on that too is that's one of the keys. You mentioned talking to the people in the MAREI group. I would do that if I'm especially a new investor. There are tons of attorneys that even just do real estate law, even forgetting other areas of law, but that don't work with investors. Maybe their clients are big commercial developers who are looking at commercial leases all day long, or they just deal with seller disclosure lawsuits or whatever it might be. Make sure the attorney you're talking to actually knows investing and what's going on. And so MAREI is a great resource, the business directory, that kind of thing. Just make sure the person you're talking to knows this area of law, because take doctors for an example. You're not going to go to a cardiologist to fix the problem with your knee. He might have a general idea of the medicine behind that, but he's not going to know the intricacies. You're not going to come to me for your divorce. I'm not going to do you very good. And so same kind of thing. Just make sure the attorney you're talking to knows this area of law, and specifically investors. Because again, sometimes it's a little different for an investor than it even is for others in the real estate industry. So.
Yeah, I have a friend that owns their rental property in their own name, and I've advised them over and over again to get get an LLC for their business, and they told me their attorney told them they didn't need to do that they could owning it in their own name was perfectly fine. And I'm like, oh, I cringe every time I run across their name in the tax records. One, you should not own this in your own name, but I can't convince them. I don't know anything.
Right.
And obviously their attorney is there for something else, not real estate. So, well, I want to thank you. We're hitting right at a little over 30 minutes, and that's about what I wanted to do. I'm sure we will have you on again when we have other issues coming up, but thank you for sharing your time. I forgot, what is your website? How do we reach you?
Oh, that's a good idea. So
that's a good idea.
So rickdavisrealestate.com is my main website. You can go on there. My email is just rick@rickdavisrealestate.com. So pretty simple if you want to email me. And I do put other videos and things on there that sometimes answer some of these questions as well.
Yeah, so. He has I go there a lot. I'll find videos or articles on different topics that relate to real estate and contract law that answers the question. So if you have a question on some of this stuff like this, I would hit his website. You might find the answer before you call anybody.